Hello. Undue influence, also known even among English-speaking people in Quebec as Captation, which is a calque from Captation en français. This undue influence is one of the three reasons to invalidate someone's will. And in some, we're talking about a situation when the person was not incapable and knew what he or she was doing, but still it was not exactly his or her free will to do so. It was sort of a duress or sort of like a fraudulent behavior of people around, so that at the end, the testator, the person who signed a will, felt that there was no other option than to sign. Even though the person might have regretted it, for example. It might be if the person was weak and vulnerable and thought that if he or she didn't sign the will, the person who was taking care of him or her would not continue to do so, and the person would be left behind, or there might be some sort of false representation, some lies about people around, saying that, oh, that son of yours or that daughter of yours have abandoned you, or they just stole money from her, or they, and so forth, like bad mouthing in many ways, just trying to present those people in the worst optics possible, with worse context possible. Sometimes it includes like cutting all the connections so that the vulnerable person cannot call anybody, cannot write an email, cannot communicate basically, and at the same time the information fed is that others don't want to talk to you, others don't want to visit you, so they just have forgotten you and so forth, something like that. So basically the creation of such a context, such an atmosphere, such a pressure on a person, altering the actual reality in his or her mind in order to make it possible and probable that in such a situation, out of some fear for the future, out of some emotion of like offense taken or something like that, the person would change his or her last will in a way that otherwise that person wouldn't do. That's important, because if all those maneuvering was present, but there were other like more significant or more realistic reasons for the person to change his or her last will, then it's not that this kind of undue influence is not taken into account. So there should be undue influence, and there should be direct connection between this influence and the actual change or just preparing the last will of the testator. In a judgment that has come like fairly recently, the judge specifically mentioned again that it's not enough that those heirs who were disinherited or just lost something because of this, that they're not satisfied, that they just suspect something. If anybody wants to invalidate a will based on the idea of undue influence, captation, that person or those persons have to prove that in fact there was something more than just simple solicitation, like simple talks or something like that. That the vulnerability of the person was actually exploited, and that these acts of exploitation actually caused this change in partition of the inheritance. Again, it's not enough that it's simply something like morally reprehensible. It should be close to fraudulent actions, well, or just duress. So, basically, many things that invalidate a contract, showing that somebody's will was not free or was not informed, so that the consent was not like free as required for a contract. More or less the same reasoning applies here. As much as we can prove, but we have to prove that the consent to sign this particular will was not free. And stupid doesn't count. It should be just not free. Stupidity, as one of the judges once said, is not illegal. It's not enough to show that it was unfair. It's not enough to show that the consequences are like not so favorable to people who were loved and respected by the deceased during the lifetime. The idea is to show that the deceased actually, the testator, was not free enough to sign this will. There are interesting remarks that, well, when it comes to an elderly person, of course, the same analytical framework as about, again, exploitation of elderly, abuse of elderly also applies here. And that those fraudulent maneuvering usually doesn't leave direct evidence, that a presumption might be taken, but out of like many coherent and serious circumstantial facts, like second or indirect facts that altogether could show that what the person did, what the person signed, was against his or her will. Like really, not out of some consideration, but his or her proper like personal considerations. Just not free. Again, the judge said that if somebody is taking care of the deceased or the testator at the time, not deceased, for example, just bringing that person to a grocery shop or to a hospital or somewhere else, helping with logistics. So basically taking care, even demonstratively taking care of some person, does not amount to undue influence. And in the paragraph 226, it's interesting that the judge basically says, even if that care, even if that show of good relationship, even if that nicety around was not sincere, basically if it was all hypocritical, still it's not enough to say that it was undue influence. Because after all, undue influence should be something that was preventing the deceased, the testator, from expressing his or her free will, free and informed will. It's hard to prove that usually, even if it is allowed, that is proven by presumption. Still, it's hard to prove. But sometimes it's possible through witnesses, through some paper trail like emails, text messages. There are some factors. For example, if the notary that changed the will suddenly was not the same notary that the family used for many years, and it was all in a rush, for example, and so on and so on. So there are many factors that the courts developed through these years. But what I try to bring up now is that it's not enough to say that something wrong was happening. It's not enough to ask questions. It's you have to bring answers to the judge. Actually, it's not enough to show that it's all wrong. What you have to show, if you want to successfully contest the will based on undue influence or captation, you have to show that there was no free will in that will. That the person was acting under pressure that that person could not bear. If that's the case, then a will might be successfully contested. Thank you, and have a nice day.